And I'm Sally Gresham. I think the hardest part is to make sure that in my own mind I have grasped what it is people want and get that down. You want to answer, Joe?
I'm Joe Basta. The thing that I find most frustrating is that oftentimes at the end of the session, we will be tired, the parties will be tired, and apart from the natural propensity to make mistakes that environment gives rise to, there's a tendency, I think, sometimes for me to want to rush. You just want, you want to get this thing over with, and I have to check that tendency and remember to take it slow and easy to make sure that it's done right.
Now I'm going to turn it over to our esteemed Joe Basta, great mediator, former board president, and great contributor to the
This little workshop was really born of a checklist that Professor Twain put together, and also Ann Pfeiffer, who's a leading mediation trainer in the state. Public were kind enough to publish in the ADR newsletter a while back a very handy checklist for drafting mediation agreements, which we're not going to give you now. We will give you later in the session. But that was really the genesis of this whole idea. It's been my experience at the center here, and also in Wayne and elsewhere, that a lot of mediators unnecessarily struggle with the whole idea of drafting mediation agreements. And a lot of the lay mediators, non-lawyer mediators, struggle for really no reason other than the fact that they sometimes feel that they're not up to it simply because they're not lawyers, which is not the case. But drafting mediation agreements does not require a legal education. It does not require that you have attended a course in contract drafting, and it does not require any mastery of legalese. I'm sure the lawyers in the room will tell you, the good lawyers will tell you that learning to shed yourself of legalese is one of the first things you've got to try and do when you get out of school, because that's not the way normal people talk and communicate. And the agreements that we seek to draft are agreements that we put together in plain and simple terms for everyday people. It doesn't make them any less legal, if you will, or any less enforceable in court. But if they're not understandable and they don't communicate the intent of the parties, they're not going to work. There was no need for anyone in this group or doing mediation agreements to worry about the details of contract drafting, because by definition you're almost always going to be dealing with two parties exchanging promises for something of value that makes up the essence of most contracts. What Sally and I would like to do is there are a couple of we have a couple of case studies. One is a relatively simple small claims case, /commercial case. The other is a domestic relations case, and we're going to ask you to pick one of those scenarios and put together, read the facts, and just outline the essence of what you would see as the mediation agreement for either one of those scenarios. And you're going to have, the way you'll have to do this is by coming up with what you think would be the ideal agreement you see emerging from the facts. In other words, you will be either king for a day or queen for a day, and just plotting out the agreement as you see it between the parties, whether it's a compromise of some kind or whether you think it would be fair and reasonable and likely for one party to get a little bit more than another, whatever the case may be. But The idea is to have you put down the essence of the agreement, and then what we'll have you do is we will give you a checklist to serve as a template against which to judge the quality of the agreement that you have put together. Then we'll let you split up in a couple of groups with the domestic relations and the small claims. Somebody can be a reporter, and then you can report back and say, we got most of this stuff first time around, so-and-so is a brilliant agreement writer. You may come up with other ideas, things that should be on this checklist that we're going to give you that are not there now. Okay, so that's the general framework, and then we give us an opportunity to conduct a post-mortem. Okay, and I don't know in terms of the gentleman's questions about legal questions.
We originally talked about. So do you want to talk about that? Are people interested in that?
Well, I have a quick answer. We can raise it in more detail. But I have what I think is the quick and dirty answer that works. I mean, it's probably a little more difficult in the execution, but at least the principle I think is not too difficult. And that is when it comes to handling legal questions, I think it is appropriate for mediators, assuming you know the answer to the question, to speak to facts. That is to say, I think it's fair game for a mediator with a domestic relations or small claims to say, this is the way the process works, okay? In terms of the filing of the complaint. If you don't get this resolved here, you're going to go in front of the judge or explaining, the fact in the domestic relations case that if you aren't able to decide things, the friend of the court will decide it for you, will make a recommendation, and then it will ultimately go to the judge. In other words, you could lay out things that are not disputable about the way the system operates. It is not appropriate to be offering opinions about how the process may operate in a given case or how it may react to a given case. So, you can explain how a party gets from Part A to Part B to Part C. That is a fact. To say to a party, if you advocate that position in front of Judge X, you are likely to get your butt kicked, is not a statement of fact. That's a statement of opinion. May be correct or may be incorrect, depending upon what you know about the operation or how a judge behaves his or herself. But I don't think offering an opinion like that is appropriate. Yes?
I agree with everything you said. The question that comes to mind is, like, if I'm in a small claims mediation like this, construction issue, and in the Construction Lien Act, you're supposed to have a written agreement to enforce your right as a contractor to get paid. There isn't a written agreement here. But he files a small claims action, and the court sends it to mediation to begin with. And I did construction litigation, but I'm not there as a lawyer for either side. Mm-hmm. But there's a deficiency in this claim. Mm-hmm. So the contractor is saying he wants $5,500. The real answer is if you go to court, you can't get a dime because you don't have a written contract. And most people who don't do construction litigation won't know that anyway, but as a mediator, I'm not there to say that to the defendant. Right. But what am I there to do if I know really it's not enforceable?
I think you're there to help them make the best deal that they can make on their own, okay? You're not there to play lawyer for anybody or to judge. I think really, some of this you start to get into some nice areas, or finer areas here, because I'm sure there are people here who will object, who will bristle at an agreement where they think maybe one party is taking advantage or getting a better deal than the other, and there will be probably an equal or greater number that won't think twice about that, because they'll say, hey, we're not here to babysit, not here to be Boy Scouts or Girl Scouts. We're here to help parties autonomously arrive at the best resolution they can. Now, having said that, you can't be a party to an out-and-out fraud, okay? I mean, you can't, you know, you can't counsel somebody on how they can beat the IRS, or how they can beat taxes and things like that. So it starts to get more complicated quickly, but I think when in doubt, drop back and punt and don't jump into the fray.
I sort of feel, I think as lawyers, you need to do a step further. I mean, you may have to say to Sally, I can't take this case and get someone else, because if something's black and white, if somebody you know legally is entitled to trouble that, landlord tenant, for example, if somebody is renting and they don't have a proper C of O, and that's happened in a couple of cases we've gotten, I think it puts you as a lawyer who's a mediator in a hard position. But I think you can also say, so in a domestic, you can say, well, what are your thoughts if the judge considers in caucus the other side to be an equitable parent? Have you thought about that? So I think you can not give them legal advice, but open that door to say, have you thought about what if the judge might consider this? And I don't think that's giving legal advice, but I think it's a fine line, and it could be troubling for lawyers if they're in that position.
So Angie, I think that's a really interesting thought, is that if you as an attorney read just, of course, you know, what they say is non-payment or something on the reason for why you're filing, so you don't necessarily have that information. But if you quickly see that your legal background would make it hard to be impartial in this case, it might be okay to say another mediator needs to come.
And I agree with Joe. I think it has to be a black and white issue that you know, like, oof, there's no way this person, you know, this person had a lawyer, but it's not like this person should get more or less. It has to be a real black and white issue, like, you know, this person didn't have a C of O, didn't have, you know, couldn't rent this apartment, and was not habitable. You know, then you're like, as a lawyer, I would definitely ask that to get off.
And there may be the situations that your antennae go up right in terms of the complexity, that your reflex action should be to say, you know, you go ahead and sign this agreement, but before you do it, you may want to consult with a lawyer on this. Best clear or a professional. The clearest example for me is in the domestic relations case. If there's a pension involved, okay, breaking up pensions can be very, and allocating pension rights can be very tricky business. It can be, you know, big time malpractice for lawyers that don't handle it properly. And I think in cases like that, you've got to be counseling people to seek some other professional advice in order to serve their interests. Now, I don't have a good answer for if they keep insisting, no, we want to do it this way, we want to do it this way. I still think they have the right to do that, okay? But you're treading on pretty thin ice.
Mike?
Yeah, I have a question that might goes a little beyond this and might be appropriate for another Brown day. Just to give an example, I was this was actually a district court case where one side had an attorney, the other side could not afford an attorney, tried to get free legal help, couldn't get it, and it was a suit over a lot of money. And what I actually asked the attorney some questions about what were the ramifications. And to his credit, I believe he spelled things out. This was a lawsuit over medical bills. But I keep wondering if in some cases there should be some sort of pro bono attorney available for disputants who do not have and cannot afford legal advice in these cases. That's a whole big other issue.
That is a whole big other issue. Okay, are you ready to switch to agreement writing?
Can I just do a quick?
Go ahead.
How does situation where you've written agreement, you've crafted the agreement, and then you see something that you say, I think, if I were you, you might want to seek legal counsel. What does that do to the agreement? What does that do to the agreement that you have that all of a sudden can be negated by an attorney coming in on either side or both?
I can make a suggestion, and that is that we adjourn the mediation to another date so that they can talk to an attorney. And I think it's a good idea to go ahead and sign that agreement so then we have it in the file, but don't dismiss the case. And so you either come back to mediation or else they agree not to come back to mediation.
And that even in general civil, not in civil?
I don't know about general civil. Is Kim still here?
No, I mean, I think that's generally a good solution
Okay.
to do that.
It sounds like big cases that could be stopped before mediation to be addressing these issues. If there
You
needs
mean
to be,
if in intake you discover it?
Yes.
Okay,
Exactly.
small claims, you don't have that privilege.
You're intaking on the fly.
That's right. Okay, who would like to do a divorce case? And those of you who would like to do a divorce case, I have 5 copies here. Bob, do you want one? I'll pass it down to Bob. I only made 5 copies. Did somebody get a divorce case already? Okay, did somebody, otherwise I have a small claims case. Good one. Okay, and then can you pick up, this is, yeah, that's the divorce case. Okay.
I think the worst.
You want a divorce? Okay, who else? Angie and...
Salad.
Yeah. Yes. You got a divorce too? Okay. Well, you're gonna have to tear up some. I don't have enough. Okay, you willing to do it? Okay, and give me your small claims. Okay, and, okay, give me your divorce or your small claims.
Small claims are on the table, are they not, Sally?
Yes.
Okay.
So, and I'll take the agreement form too.
So does everybody that wants to do the domestic relations case have the case study?
Yes, we did.
And everybody else has the small claims case, the civil case of their own volition? Okay. And you all have pen and paper presumably, so
Thank you.
take a look at
Who doesn't have a case?
take a look at the facts and put together the essentials of, what you think would be the ideal mediation agreement for these parties.
Way of doing it. For one thing, you can make it much more flexible. You can put things into an agreement that don't make sense on a consent judgment. But certain people, and like credit unions or whatever, are almost never going to use a mediated agreement, and they absolutely want the judgment form. For the first time this year, I had someone call me up from Florida and say she could not buy her house because the judgment form had not been, the plaintiff had not released and said she paid, not a settlement of a judgment. It wasn't settled, and so there was like a lien on her because of that 10-year-old, not 10-year-old, it was like 6-year-old, and she had paid it. So that's another reason that I think it's better to go with the mediated agreement. Some people say you should offer them the alternatives. I don't think people can, they're in their state of conflict, that they can absolutely assess all of that. And so that's why I just go automatically with, let's start with the mediated agreement. And then if you hear the doubts, I don't think this is going to work, I don't think the person's going to pay, then you present the alternative. That's the way.
So the trade-off is, in the event of a mediated agreement, if there's a default, you, as the plaintiff, have bought another, or the agreed party have bought another lawsuit. You got to file another claim to collect on the agreement.
But the expenses of that should be paid by the defendant.
Right. But the other side of the coin is you go to consent judgment. You can go back to the court, but the defendant has a judgment on his or her record and may balk at that. So.